HR record-keeping obligations in California, what to create, retain, and destroy. My name is Julie Dorr, and I want to just welcome all of you for joining us. And I also want to thank you for being so accommodating to our schedule change from last week. We have a great presentation today for you. It'll last approximately 40 minutes. And the remaining time available is for your questions. Now, we have a large group on today, so I want to make sure that all of you know that you can certainly submit your questions anytime during the webinar. And there's a section over that says questions. Just type your question in and hit enter, and we'll hold those for the end of the webinar. If you prefer, you can certainly email me. My email address is right there on the screen. Just email it, and I will also ask questions of our presenters today at the end of that their presentation. So let's go through this real quickly. We got to do some housekeeping. First, want to let you know, for those of you that were expecting a presentation this morning, you're not going to get that. You're going to get it after our webinar today. And along with that, we're going to be sending a link to the actual recorded webinar. We think that's a richer experience. So you have the recording as well as the actual presentation. And then also, again, if you have any questions, because we have a large group on today, feel free to access the information on the actual webinar. All the contact information is on there. So feel free to contact either of the presenters afterwards so that you can have your questions answered in case we run out of time. Before we get started, please note that this webinar and all of the accompanying materials are protected by copyright and that the entire conference is being recorded. This presentation, as well as anything that you say on this, is not constitute as legal advice, and we recommend that you consult with legal counsel to address your specific situation. We have a lot of contact coming in here today, so I'm sorry if I'm a little distracted. So I'm going to get over to our speakers so I can handle some of the administrative stuff. Let's first welcome Linda Duffy. Linda is the president of Ethos Human Capital Solutions. Linda works with business owners and executives to provide strategic human resources direction, develop leadership talent, and increase organizational effectiveness. We also have with us, joining Linda, attorney Marla Merhab Robinson. Marla is with the law firm Merhab Robinson, Jackson, and Clarkson, where she's a partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisitions, real estate, finance, and employment law. Linda, I'm going to turn over to you because I've got a lot of administrative questions going on right now. So take it away, my friend.
All right, thanks, Julie. Hi, everyone. Thanks so much for joining us today. And again, just to reiterate what Julie said, our apologies for postponing from last week. It's been, boy, just an eventful couple of weeks, and also apologies for not getting the slides out ahead of time as we normally do. But my laptop failed over the weekend, so we're a little bit behind the curve compared to where we normally are when we do a webinar. So we will get those slides to you, and then again, you can always contact me or Marla with any questions we don't get to today. All right, so let's start by going through the agenda. Here are the things that we plan on talking about today. I'm going to quickly review the posting requirements, just the things you need to post throughout your buildings, and make sure employees have access to. We're going to talk about the different documents, sort of in the life cycle of an employee, how long you're going to keep each of those documents, and we also have put on the slides the references to the particular laws that bring that up, so you have that information to reference as well. How to keep personnel files. I have this discussion with my clients a lot. I wish I could tell you that there's one specific answer, but there's different opinions on how to keep your personnel files, so I'm just going to address different ways I've seen people do it. And then Marla's going to talk about access to employee files, meaning, you know, what are your requirements when someone comes knocking on your door, if you're an HR person or a business owner and says, I want a copy of my file, or I want something in my file, and what you're required to do. She's also going to talk about problems with documentation that we've seen. Give you an example of a timing problem. This goes back sort of to how long to keep documents, but example of a timing problem, and then talk about a few different things with regard to document storage. So with that, I'm going to go ahead and just touch briefly on the posting requirements. So if you go out and you look and just Google California posting requirements, you'll see the list on different websites all over the place. There's 16 federal and state required postings. I didn't list them here, but most people have a pretty good sense of what they are. It's things like equal employment opportunity is the law. There's different notices to employees in California with regard to unemployment insurance and disability insurance and paid family leave. There's, of course, the California and federal minimum wage laws, your rights under various laws like USERRA, which is having to do with vets and military service. There's different safety requirements, all sorts of things. The easiest way, to be honest with you, that Marla and I advise our clients is to just go buy the laminated posters from Cal Chamber. In fact, if you Google posting requirements, they're going to pop up as soon as you put California posting requirements in. It's going to pop up as a paid ad on Google. So just go to their website. They're pretty inexpensive, and they have laminated posters that you can just put up around the building. So the requirement is that employees have access. So most people use a lunchroom or a break room, or maybe a copy room or some place where employees can go and read all the information. You want to make sure, though, that everything is included. And so you should do a little bit of investigation there. Make sure everything's included. There are also additional postings that could be local. So, for example, if you're a business in San Francisco, your minimum wage is different from the state and the feds. You have a couple different laws you have to be in compliance with. And so you want to make sure that if there's anything local that wouldn't be state or federal, that you make sure that you have those posting requirements as well. The other one that I see most people miss is the Industrial Welfare Commission orders. So every company in the state of California falls under one of the IWC orders. And what you need to do is go to that link that we've provided on the slide there, and there's actually a way that you can determine which order you fall under. You can simply print it out off of their website and then just tack it up. If you order them from the website, and I don't even know if you can get them anymore, you can probably get them from the website. They're sort of like a calendar, if you will. It's like page after page, it sort of flips up like a calendar. That's a wall calendar. But you can just print out the pages, staple them together, and stick them up there. But that is not something that Cal Chamber provides because it's industry specific. So you have to make that determination for yourself, print it out, and then post it where you put the rest of the posters. So that's the most important thing to know about the posting requirements and the place on audits where we see the biggest mistake with posters. All right, document retention. I'm going to sort of go through these slides pretty quickly because, to be honest with you, at the end you'll hear what our recommendation is about the document retention, but we are going to break it down for you so you know what types of documents, for the most part, have to be kept and for how long. So the first one has to do with recruiting, hiring, job placement records, and I've left you sort of a list there of different examples, like your applications, your resumes, things like that. Generally speaking, anything regarding your job search, the ads that you've placed, the people you've interviewed, applicant logs, resumes, anything like that, you have to have a 2-year look-back period according to the laws that we have listed there. So that's the first group to know. The second group has to do with payroll records. Now, payroll records could be everything from the things that have to show up on paychecks, like their name, address, everything like that. Individual wage records, time and date that the work week begins, their hourly rate, their OT earnings, everything like that. That has a 4-year look-back period under both the FLSA and also the California Unemployment Insurance Code. And for W-4 forms in particular, that gets split out, and it's 4 years beyond the effective date. So if somebody comes into your office and changes a W-4, you have to maintain that old one for 4 years beyond the use of that W-4. Now, that's for payroll records, but then they also have a different category called employee wage records. There's a lot of overlap between the two, and the California Labor Code spells out what you need to have covered here, and that's for 3 years. So you can see right away how this is going to get pretty confusing when you try to split it all out, because there may be one law that requires something for 4 years, and then you turn the page and it says, oh, but for the employee wage record, it's for 3 years. And that can get pretty confusing pretty quickly. Employee personnel files, so things like records of promotions, demotions, disciplinary notices, termination files, training and testing, anything like that, employee physicals. There's a whole bunch of different laws going on there, and this is 3 years after employment. So 3 years beyond employment is what you need to keep all of that. Then we get to the I-9 forms. So I-9 forms, I'm going to talk about how to store these, but I-9 forms under Immigration Reform and Control Act have a little bit different rule because it is 3 years from the hire date or 1 year after termination, whichever is later. So if you have an employee that works 1 year for you, you still have a requirement to hold that for a total of 3 years. If somebody works 10 years for you, you have a requirement to hold it 1 year post-termination. So I hope that's clear for everybody. I have to tell you, I-9 forms is probably the area in terms of documentation where we see the biggest mistakes. We could do a whole webinar, and we're actually going to do one later in the year on immigration. I-9 forms get filled out incorrectly all the time, and so when we go in and we do an audit, I've never, in fact, ever audited a company where there weren't mistakes on the I-9 forms. So make sure that you pay particular attention on getting those correctly, especially since you have to hold on to them. The next set is affirmative action programs and documents. That's not going to apply to most of the clients on the call probably, but if you have government contracts, you'll know if you're subject to affirmative action plans, and so that's under Title VII and Executive Order 11246. That's going to be for 5 years. That's discretionary, but we really recommend that you hold on to them at least 5 years. And then employee health records. So this would be your OSHA log, your records of injuries, your workers' comp claim files, everything like that having to do with employee health records, drug and alcohol testing records, everything like that. OSHA and Cal OSHA both require that for 5 years. Now, there's one huge exception on the employee health records, and that has to do with chemical exposure. So my first job when I was in HR was for a heavy manufacturing company, and we worked with a very toxic material called beryllium oxide. It affects the body in a similar way to asbestos. So think, asbestosis. But there's a latency period between the time of exposure and the time that someone might develop symptoms. And so that's why for any sort of chemical or toxic exposure record, it's actually 30 years beyond employment. You have to hold on to those records. So the question I would pose is, okay, so you hold on to those material safety data sheets, or you have other records where you've done testing maybe to document employee exposure, but if you don't have some of the other records regarding where they worked, what department, what their job was, what their job duties were, I'm not sure how holding on to the MSDS and a few other documents related to exposure is going to help you unless you can put it around a context. But the requirement is 30 years beyond employment for the exposure records themselves. Okay? It doesn't require that you actually hold on to the personnel file that long, but I'm just going to suggest that if you're working in the industry where that's the case, you might want to think about expanding the scope of that to include some information about what the employee was actually doing. So if somebody does get sick later on down the road, it will either help you prevent other people from getting sick or defend yourself if you don't think that the person had the exposure there. The next one is on employee benefits data. This is under ERISA, obviously, a federal law. So benefit election forms, cover notices, all of the summary plan descriptions, anything like that. It's 6 years, but not less than 1 year following the plan determination. So you want to make sure that you have all of those records. That's longer than everything else we've talked about so far, except for the exposure records, so 6 years under ERISA. FMLA records, leave policies and benefits, the hours used, make sure you have to capture an intermittent leave, anything regarding a dispute having to do with the designation of the leave, the application for the leave, your internal forms where you designate leave, all of that has to be kept for 3 years under FMLA. And then just a couple more slides on this. Under the California income tax records, there's a requirement to keep them 6 years. Federal income tax records are usually 3, but it can have exceptions up to 15, and that's why we have 3 to 15 years. Social Security and Medicare records, 4 years after the tax is due, same for unemployment insurance. And then records regarding administration of polygraph exams is 3 years after the exam is administered. So if we go to the next page, we're just going to summarize all of this by telling you what we recommend to our clients that we do, and that is keep all of the employment docs at least 7 years. The reason for that is there's a fraud statute that's 6 years. Marla's going to talk a little bit and give you an example of why it's important to keep the records a little bit longer than the requirements that we spelled out on those other forms. So just know that because the fraud statute is 6 years and the way taxes get filed the year after of the tax year, we're recommending everybody just keep everything 7 years, and that's going to make your life a lot easier than having to worry about 3 years versus 4 years, or this is 6 years and whatever, especially since for the most part you're going to keep all of these documents in the same file. And that's when we're going to transition right over to how to keep the personnel files. So I have this conversation with my clients all the time. Marla and I have been having it back and forth, back and forth, back and forth, because I wish I could tell you that there is one simple, straightforward explanation that everybody uses, and the fact is it's just not the case. So the question is things like, are we going to have multiple files? Are we going to keep one file? There are different things that you need to keep for sure in the personnel file. And so we've made a list here. And it's pretty much everything having to do with the lifetime of employee, if you think about it. So everything from recruiting, screening, and hiring the person, what their job description is, if you write those, you promote them, you transfer them, you demote them, whatever, their compensation, education, training, all the things I have listed here. But what you really need to think about is a couple things with regard to personnel files. One is who needs access to the files and why. Who needs access and who has access, I guess, to both of those, because the biggest concern from my point of view is going to be privacy. So there's a lot of discussion about whether you should split things out of, and have multiple files. I do have clients, I know organizations where they keep a personnel file, they'll keep a confidential file, they'll keep a medical file, they'll keep a payroll file, they'll split it up into all sorts of different files, and I always ask them why. And usually the answer is because they thought that was the requirement, which it's not, or they say, well, because managers come in and ask for files. So let's say a manager comes into your office and says, I want to see so-and-so's file because I'm thinking about moving them in my department. My answer was always, okay, tell me what you want to see. Do they need to see somebody's Social Security number to move them into another department? No. Do they need to see what their benefit enrollment forms are? No. But does that mean I have to split those out into separate files? I don't think that's the case either. So if someone comes in and says, I'm thinking about moving this person or transferring this person to my department, or I want to promote this person, and they usually, what do they want to see? They want to see performance appraisals. They want to see, does the person have any written warnings, if there's been any other issue. Maybe they want to see trading records or something like that. But usually it's performance appraisals and written warnings. And so what I would do is just pull those out of the file and just sit with the person and say, here you go. Perhaps make copies, but usually I would just pull the original, sit them in an office someplace and say, go to it. They spend 20 minutes reviewing it. I put the file back together, and it's a done deal. And I think that's usually going to be the easiest way for people to get around having multiple files, is just restrict access to the actual file to the people that really need to see it on a regular basis. And usually that's going to be, your HR team, every once in a while a more senior manager, and perhaps somebody in payroll, except usually they're going to have their own payroll files. There are certain things, if we go to the next slide, there are certain things not to include in your personnel files. So having said all that, I do recommend that you split out a few different things. Marla can talk about what her recommendation is. We're pretty much on the same page here. So one is medical and insurance records, including drug testing results. So anything that's going to be medical related, it would not be uncommon to split that out into a separate file. I know, again, when I was at that heavy manufacturing company, we sent people for physicals on a regular basis. We kept that in a separate file with their medical and their benefit information, because also sometimes you'll have employees come in and bring you a claim form, or they want help with something. So you don't want anything that's going to reveal a disability or medical information inside the personnel file. So we usually just had a separate file for that. So where I came from, we always had those two separate files. Anything about EEO, so self-identification forms, data records that you collect with the application, anything, again, that's going to reveal a personal characteristic like that, or a protected category, I should say, could be split out, and there's just no need to do that to keep it in the file. Documents created in response to litigation or during investigations or in preparation of litigation, as well as attorney-client privilege communication, should not be kept in the employee file, because Marla was going to tell you that you would have to copy that and reveal it, and so you want to make sure that you don't get yourself into that trouble. Workers' comp claims, typically, I've always split out and just maintain a separate file, not by employee, but just have that claim itself in a separate file, because that's going to go on for a long period of time. You want to be able to access it and keep track of workers' comp claims. Information obtained from background investigation and reference checks, you do not need to provide the employee under the law, so you can keep those separate. I usually keep those actually with the hiring or recruiting file itself. And then, as I mentioned before, the I-9 forms and related information. Now, one thing I'll note is people have different schools of thought also on whether or not to keep copies of the documentation I personally have always kept copies of the documentation and stapled it to the I-9 form. Some people keep copies of the documentation and put them in a separate file. I've always kept the copies of, like, let's say somebody brings you a passport or someone brings you their driver's license and social security card. I've kept copies of the document and attached it to the I-9 form because in a busy HR department or whoever in a small company, one person doing the hiring, it's easy to get sidetracked when you're when you're doing all the paperwork. And you may go back later and find that there's a mistake, or you're auditing the files and you may say, oh, we forgot to put the expiration date on that driver's license. So if you have a copy of the documentation, it makes it really easy to be able to go back and just correct it right then and there. You want to make sure, obviously, you don't attach copies of bad information. You don't want to take somebody else's picture. I did an audit of a client, and I turned the form, and I was looking at the documentation, and they had an alien registration card, and they had a driver's license, and they were not for the same person, but those were the two documents. Again, they don't even need those two documents, but those two documents they put on the form themselves. And when I asked, she's like, yeah, I didn't think it was him, and it clearly is not from the picture. So you don't want to make that mistake and hold on to information that would be incorrect in any way. With that, I'm going to turn it over to Marla, and she is going to pick it up from there.
Thank you, Linda. Fabulous job as always. I just loved, I could sit and listen to you talk all day long. I just want to chime in on what she said. There are lots of schools of thought on what to include, what not to include, and we're talking about separate files. When I talk about separate files, I talk about separation, not separate files so much within the same place. And the reason for that is I find that clients will lose files if they're not all kept together. So the personnel file may, for example, contain a manila folder that has all the medical and insurance records that's marked accordingly so that we know that's not something we're going to give to the managers. So that when we ask for the personnel file, we get everything, including that list that Linda said, but not to include. And when we ask for it, it's for a particular purpose, and I'll get into that in a little bit. So let's talk about access to personnel files. Effective January 1st, 2013, some of you may recall Assembly Bill 2674 amended the Labor Code section, for those of you who are section geeks, 1198.5. Prior to the amendment, you probably recall that employees had the right to inspect or copy signed documents. So they could inspect anything in their personnel file, but they were only entitled to a copy of something that was signed. Now they have the right to inspect everything or copy anything related to performance or grievance. So what would that be, keeping in mind those lists of documents that Linda just gave you? Is it all? We don't know. We do have some court interpretations that have broadly interpreted that it includes applications and attendance records, but we don't know at this point. But they're only entitled to performance or grievance documents, and there are some that would clearly not be part of that. So it further amends to require the employer to respond to written requests within 30 calendar days. Again, this request must be in writing, and it's from either employees or former employees. If it's from employees, it can also be from their representatives. The failure to respond to this request can result in a $750 penalty, which can be quite significant if you have someone who's requesting for several employees, which we've been seeing more and more. Also injunctive relief, which means a demand to turn over the documents, and attorney's fees. There is a limitation. It limits the number of requests by employee representatives for copies of wage records to 50 per month, which seems a little ridiculous when it's a 30-day compliance. Why would you get 50 requests per month? What this is designed to prohibit is the employee who comes in and says, okay, here's my written request for my application, and then brings in another request for a separate document, and another request, so that the requests are not all in one document. Okay, the AB 2674 also amended Labor Code Section 226 to require the production of copies of wage statements. And the wage statements need to contain certain information, which I'm going to go through with you in just a minute. The significant amendment here is that this request can be made orally or in writing, and the employer must respond within 21 days, or a penalty will be issued, or actual damages, whichever is greater. So this is a little frightening to me for my employer clients, because you can always have an employee who claims to have come in and made a request orally. So I really encourage putting in place some practices that we'll talk about later on who's going to be responsible for this so that we can help document how it happens. The amendment specifies that itemized wage information can be kept electronically, which is good because a lot of people have moved that. This can also be from employees or former employees. So I'm going to give you a list of the information that is required in wage statements, and I encourage you to write it down if you're not one to go look up 226 sub A of the Labor Code, because we're seeing lots of errors here. Again, it just went into effect January 1st of 2013, but the attorneys have already made lots of demands for these statements, and we're seeing errors as they're coming across from our employers. So the first information that is supposed to be listed is the gross wages earned. The second is total hours worked, unless the employee is exempt. The third, if applicable, piece rate units earned and the applicable piece rate. The fourth, all deductions. Now here's one of those areas we're seeing a lot of errors. The employer won't list a deduction that was made even though they had consent to deduct from the employee. They won't list it on the wage statement. All deductions must be listed, not just tax deductions. So if you have an employee who's borrowed money and you're deducting the repayment, that's got to be listed too. Net wages earned, number 5, I'm sorry. Number 6, inclusive dates of the period for which the employee is being paid. This is another area we're seeing errors. Number 7, the name of the employee and the last 4 digits of the Social Security number or the employee ID number. The employer is not required to use the Social Security number as the employee ID number. You can use any form of numbers, numerical and alphabetical. Number 8, the name and address of the legal entity that is the owner. This is another area we're seeing a lot of errors because some entities don't use their legal name. For example, if you're a corporation and your legal name is ABC Corp, but you do business as Ready Quick, and the check wage statement says Ready Quick, then you're not in compliance with this. So this is another area we're seeing errors. Number 9, all applicable hourly rates during the pay period and the number of hours worked at each rate. Okay, on to practical implications, which I would suggest is really just another way of saying best practices. These are some things to consider in trying to avoid these errors. Consider creating a request form for inspection or a copy of personnel records. This will help with getting it in writing if there's a form available to the employees, as we talked about the oral issue. It doesn't mean that the employee has to use that with respect to wage statements only. They do with respect to the other personnel records, but it will help. Consider designating an individual to whom the request should be made and put processes in place to ensure compliance. If we communicate through the handbook or other means to the employees, this is what's expected and this is how it's done and this is how you'll get it done, then they will comply. And the code allows for that too. It allows the employer to designate who the employee or former employee must make the request to. And that's often very helpful in determining whether or not the requests are made properly. Train HR employees, obviously, and ensure you can reproduce the wage statements. Again, because we're allowed to do it electronically, that helps. You should track the dates on which requests are made somehow. Put in place some form of tracking, either electronically or on paper if you're still using paper. Before turning over any of these records, one of the best practices that we use is we ask our clients to send them to us. So our clients very often will send us the demand letters they've received or the request letters they've received from employees' attorneys or sometimes from the employee themselves to have these records. And what we tell them to do is gather them all because, as we just talked about, sometimes they're in different places and different files. Gather all the records and send them to us so that we can review beforehand. And there are different reasons for the review, and I'll touch on some here and I'll touch on some when we talk about problems with documentation. But one example here is I very often have an employer say, we terminated this employee because of performance. And I say, well, did you warn this employee? Well, yes, of course, the written warnings are in the file, but maybe the verbal warnings are not. And I say, well, why not? Well, my managers, it's very difficult for them to remember to send a note to HR or to accounting that they verbally warned this employee. I said, well, let's make it easy for the managers. We have to figure out how to do that. The best example I can give is of manufacturing plants where a lot of times the supervisors are on a line, and they always have a desk with a blotter on it. So I always tell them, if you're going to be giving verbal warnings, just write it on your blotter. So today I told Susie Q she didn't have her safety glasses on. Just put it on April 29th, whatever day it was. At the end of every month, fold up your blotter, throw it in the drawer. I promise you that if it comes time to terminate Susie Q, we can pull out that blotter, we can make copies of it, and get that portion of it into her personnel file. And it's a great piece of evidence if we have to go to trial. So that's a reason for getting the file to the attorneys. Let them review it and see what is there. I'll give you some other reasons in our next slide when we talk about problems with documentation. These are common problems we see all the time. Linda in her auditing practices and us as well. But more often they come up after it's too late. So we want to make you aware of them now. So the first is lack of documentation. And I gave you that example of no evidence of verbal warnings, even though there was quite a few verbal warnings. We want to make sure that doesn't happen. Linda had already discussed the I-9s and the wage statement errors I went over. Those are also problems with documentation. Separate supervisor or otherwise files. Again, this goes to the comment of where do you keep the files, how many files do you keep, are different people keeping the files. I've had some files, personnel files that are kept in an HR or accounting department, and then payroll files are in a different department. This can become a problem because what the employee is asking for, we need to make sure that we're complying with giving what they're entitled to. Investigations. I had a real-life example of this, unfortunately, about 14 or 15 years ago. Had a client who had undertaken an investigation of whether or not the company had complied with FMLA. They did the investigation internally, and one of the senior executives of the company wrote to the HR department in a memo and said, we've discriminated against this woman, we need to pay her. Now that's a document that is discoverable in the event of litigation. That would be a 20 by 20 piece of evidence to show a judge or a jury, look, even their own people are admitting discrimination. We always tell our clients, do not make a legal conclusion in any of your investigation reports. If you're investigating sexual harassment and you have to come to a conclusion, you can conclude that there's unprofessional behavior, unacceptable behavior, but don't conclude that there was sexual harassment. That is a legal conclusion. Inappropriate behavior, those are the types of terms we want to see. So be very careful when we go through the files. Another reason to deliver to your attorneys to make sure that there's not language in there that's going to create potential liability for the company that shouldn't be there. Performance appraisals. Linda brought this up to me actually at lunch the other day, and I had not even thought of this, and she's absolutely correct. A lot of times performance appraisals are not reviewed by anyone for discriminatory language. For example, saying Joe is too slow because he's so old or he's older than everybody else. If the performance appraisals aren't being reviewed at a higher level, that at least HR or executive VP, nobody might be looking for that discriminatory language. So that's another reason to get it to the attorney to look at. Emails. Lots of times there's emails back and forth about particular behavior or performance issues with regard to an employee that don't make it into the personnel file that should. And when we inquire about why the employee was terminated or why an action was taken against the employee that may have resulted in the request for the documents, we may discover that and say, print those out, let's get them in here. Why aren't they in here? Social media is just the common term phrase you hear all the time. It's always there, it can't be deleted, so you just need to be aware of what's out there. And then timing issues. I just wanted to give you that example that Linda advised I might be giving. And it's the next slide. This goes more really to statutes of limitations and potential lawsuits. Let's just assume the following facts, that we have an employee named Sue who has a written employment contract. Her contract ends on January 1st, 2014. Written contract statutes of limitations on them in California are 4 years. So Sue has 4 years from the wrongful act to file a lawsuit. And she's going to claim her wrongful act was wrongful termination. So she has the right to file a lawsuit until January 1st, 2018. And she does so timely. Her attorney timely files it on December 31st, 2017. Well, a lot of recommendations on retaining her personnel records, you might have seen, were for less than 4 years, because those are what's required by the statute that requires the retention of the records, not by the statute of limitations. And many even employers' attorneys would say, oh, just keep the records for 4 years. But you might not have received that lawsuit until 4 years and 2 months or 4 years and 3 months. And if you've destroyed those records, you've destroyed all the evidence that you would have to defend against Sue's lawsuit. So that goes to our best practices recommendation that Linda stated earlier. There are so many different, as she pointed out, that are required in the statutes. 2 years here, 3 years here, 4 years here, 6 years here. We recommend 7 for all, consistent with what the CPAs recommend for taxes. With one exception, I would say, and that's the I-9. I would get rid of the I-9s as soon as you can legally get rid of them. And that's that 1 year after termination, as Linda pointed out. And also remember that just a tiny comment on the statutes of limitations, because I hear this all the time on wage and hour claims. The statute says 3-year look back, but if you bring a claim on the written contract, it's going to be a 4-year look back. And vacation, because it's not wage and hours, it's going to be 2 years if it's an oral employment agreement and 4 years if it's a written employment agreement. If you have an offer letter, you're going to be deemed to have a written employment agreement. So document storage. The issue here is, what do you prefer? What is consistent with your company's culture? We've got employer versus third-party storage. It's on-site with you or off-site. Obviously, that doesn't work for current employees. You need to have them there with you. But for former employees, hard copy versus electronic. And remember that there's expenses, obviously, incurred with all of these. And then remember that we now have electronic signatures recognized under the federal e-sign statute and the California Electronic Transactions Act. If you want to look at the relevant statute, it's California Civil Code Section 1633.7, which basically provides that a signature cannot be denied legal effect solely because it's done electronically. There are some exceptions, certain types of contracts that are accepted to, but I find more and more employers are moving to the electronic signature. I wanted to just add, that's the end of my part of the presentation, but I wanted to add, for the benefit of the attendees, if anybody would like us to send them the posting requirements, the list that Linda went through quickly, but is covered in the One for All by the Chamber of Commerce, which we both do recommend. It's something we just have on our annual calendars when we buy our own. There are a couple requirements that are not on that list, and we can email you a list of all of the documents so you can check it against your form from the Chamber or somebody else if you're buying from somebody else. Just shoot me an email, let me know. And then with that, I'm going to bring Linda back in and turn it over to Julie.
Great. Thank you very much, ladies. And Marla, on that vein, with supplying some other documents, you know, the people would like that, as well as you had a list of the wage statement things to look out for too. There was approximately 9 of them. Do we have that somewhere too that some of our listeners could get as well?
Yeah, I can create it.
Okay, great. So again, so I'm getting some emails in here. We will create links to that, and we got a number of questions beforehand too. So let me just walk through this real quickly. You didn't get the presentation ahead of time, but what we are going to do afterward is send you a copy not only of the PowerPoint slides that were used today, but we're also going to send you a copy or a link to go view the recording of the webinar, because of course we're recording this whole thing. So you'll be able to get that very easily from just the email that we'll be sending you afterward. In addition, Marla, I'm hoping you'll, because I'm getting a ton of responses right now, many people would like to have that, not only the 9 wage items, but also the copy of the posting requirements. So how about if we put that all in one easy email? You guys can click on whatever links you would like, and then we'll do it that way. I think that might be easier. And again, the presentation will include email addresses of both Linda and Marla should you need to contact them directly. And everybody's liking that idea, ladies, so that's a good thing. So anyway, that wraps up that wraps up the presentation portion of that. We will go on now, right, and allow you to ask any of the questions that you have. Again, we have a large group on today. You're sending obviously the Q&A is working. So again, just to go over it for those of you that may not have had a chance to type in your question, just click on the questions box that's typically over on the right-hand side. Click on that, type in your question, hit send, and then I will share that with both Linda and Marla to address. So let's get started. We're going to go back a little ways to the beginning of the presentation, and we're talking a little bit about federal postings. And the question from Marie is, can we post the federal postings on our internet page as a reference? So I know you guys mentioned break rooms, and that's typically where you see them, but can, a lot of people have intranets or, ways to communicate internally with their employees. Can it be posted on an internet page?
Yeah, I think that's fine. I mean, I think more and more the government's catching up with how people actually live in this world and work in this world. So if you have an intranet, I would make sure that probably along with new hire documents, or maybe when people have to log into the intranet, some way of reminding them where they are. But I think it's fine that you can put all the posters there and all of the notices that you have to give employees, and just make sure that they know where they are and probably get some acknowledgement of that. And I think you're fine.
Yeah, I would just add to that to make sure that the employee has access to that via your computer that belongs to the employer, whether it's a smartphone or a computer or something, because it's the employer's obligation to make sure that this is available for the employee to see. That's why lunchroom is often used. But you do have those issues. It's a great opportunity to address those issues of employees who work off-site. I also have an employer that is a temporary agency, so they're considered a dual employer, so they're sending their employees off to other employers. They need to make sure that the companies they're sending their employees to also have postings. So they have to have them for their site, and also make sure that their customers have them as well.
Okay, great. And is there any problem having all this stuff online in like a PDF form, as long as it's on a secured file or a secured site?
Again, I think it's fine to do it that way. I have often recommended that to clients. Keep in mind, though, what for your workforce, right? If you've got, let's say like I've got a client that's a machine shop. The guys in the machine shop or the people in the machine shop are not going to access computers. So you might have to have them posted where they go take a break or a lunch or have access to them. But for your office staff, you can put them on the intranet, something like that. So you just have to make sure that everybody has access. You can put them out in whatever form as long as they can access them.
Okay, good. Thank you. And we seem to have a lot of questions here about storage and how to, actually display this information. So I'm going to keep going with here.
Julie,
Larry,
let me go back and add one thing.
Okay.
You have just keep in mind you also have to update them as things change, right? So don't put them out there and then think they're going to be good forever. That's the one benefit about buying them from the Cal Chamber. They actually sell sort of the update insurance, if you will. So like, for example, minimum wage is going to change July 1st. So you would need to always be aware of what's changing in the law, usually on an annual basis, first of the year. But something like this, where the law changes July 1st, you would need to go in and update the minimum wage posters.
But the Cal Chamber does it for you, right? So that's what she's trying to say. It really is, the Cal Chamber is an amazing source for everyone. And I tell clients it's a big competitor of mine. They do a lot of the same things I do. It's a competitor of Linda's. They help you write handbooks just like we do. But the one area they really have right is this poster, putting this together, the poster, and selling the posters.
Okay, good. That's good advice. And keeping along with those electronic files, we talked a little bit about the folders and what not to keep and what to keep. When you're doing an electronic filing system, is it okay to have subfolders, so for, say, like medical records or workers' comp, under the employee file? So maybe they don't electronically live in the same file, but there's subfolders created.
Yes, that was what I was suggesting. Yes.
Okay, good. And go ahead.
No, I was going to say I agree absolutely. Not only would I say, can you do that? You should do that, and it's going to make it a lot easier. Again, if somebody needs access to something, you can give line item access. So somebody like a prospective manager or even a current manager wants to be able to see their employees' last performance appraisal as an example, and they can give line item access to those folders, but not everything else. That's perfect. So again, think through what your business needs are first and foremost, in addition to whatever the legal requirements are.
Okay, great. And Larry's just asking and confirming somewhat, do I-9 forms have to be kept separate from the personnel file? So are they isolated in their own folder, if you will, electronically, or actually in physical form, or can they be batched in some other way with a person's personnel records?
Okay, so there is no legal requirement to keep them separate. It is highly recommended by all the attorneys I know that work practice in this area and the consultants like Linda that you do. And the reason for that is that you do keep them separate. The reason for keeping them separate is if the agency comes in to audit them, you have to give them to them. And if they're separate, you only have to give them the I-9s. If you give them the entire personnel file or anything else and they see anything suspicious, they are allowed to share that suspicion with any other governmental agency. So for example, if they see what looks to be discrimination, they can call the EEOC and say, hey, we just happen to be at ABC Co. and we think you should go over there and take a look at this. If they see something tax-wise, they can call the IRS and say, we were there auditing I-9s and we witnessed this. If they don't have the opportunity to see that and they only look at the I-9s, that's all they're going to address. That's the only agency you're going to deal with.
Okay, good. Thank you. And Maggie has a question. Do we need to keep the original file for agreements, drug test results, and medical insurance records, or is an electronic file sufficient for audit purposes?
Electronic file is fine.
Okay, okay, good. And then for I-9 retention, do you keep the I-9 only for 3 years for those employees that are currently employed?
So, right, so you keep it for a minimum of 3 years and 1 year post-employment. So if I hire Marla and she works for me for 1 year, I have to keep it at least 3. Okay, so let's say she works exactly 1 year for me. I have to keep it a total of 3 years. So that case would be 2 years beyond employment. But let's say she works 5 years for me. I still have a requirement to keep it 1 year beyond employment.
Okay, good. Marla, do you have anything to add to that?
Nope, she's right on.
Okay, perfect. Isidora's wondering, is there an actual statute that employee files should be in a locked cabinet? And, if there's not a statute, is that just a best practice that you guys would recommend even if there isn't a statute?
Oh, that's a tough one. I can't remember. We've been advising locked cabinet for so long. Shoot me an email, whoever asked that question, and I'll double check. I've been practicing in this area for 27 years, and I can't remember if that came from a statute or just a best practices recommendation.
It's definitely a best practice. I mean, I would never leave employee files in an unlocked cabinet, because I mean, you've got so many different privacy concerns. I mean, think about it. Everything about identity theft that you're talking about these days in the news and everything like that, in addition to protected categories, you just want to limit any sort of exposure and any potential claim that someone could bring against you. And the easiest one, and I've had people complain I remember a complaint one time that one of the HR coordinators didn't have an office, and they were concerned that people were walking by your desk. And I'm like, well, it is what it is. Stay out of the HR office. So we would make sure everything was put away at the end of the evening. Everything was locked up. It was in a locked desk drawer if we were working on a file. Never would leave it unlocked.
Okay, great. And Larry's wondering, and this might be something an off-line topic, but he's wondering if you can talk about the new rules for FMLA in California. Is that a different webinar topic, ladies?
Yes.
Okay, good. Deborah is asking, are you finding companies starting to store employee information in the cloud? And, it seems like we're getting a lot of questions on electronic storage and the safety around and security around storing, and obviously you have a lot of employee social security numbers and confidential information. So any recommendations now with, intranet versus cloud versus all the other ways to access documents electronically?
I'll address that, Julie, because it's something that we address as lawyers quite a bit. The cloud is great, except you do have duties as an employer to maintain, as Linda was saying earlier, some of this information as confidential. Not to the same level as an attorney-client privileged confidential communication that we have, but you still have that obligation. So if you are going to use anything in the cloud, then you need to read the terms and conditions of whoever you are using it with. So for example, years ago, I always wanted to engage constant contact as a way to stay in touch with my clients and prospective clients.
And when I read their terms and conditions of use, I couldn't, because one of the things in their terms and conditions was that they owned the data. They owned the information, and they could look at it at any time. So if I input my client's name and address, they could go in and look at it, and they could use it. And I couldn't, because my practice has such a high confidentiality privilege, I am obligated under the rules of professional conduct to keep the information confidential and not disclose it. I can't even tell you who my clients are without their permission. So you have to look at the terms and conditions of use for whoever you're looking at for potential storage of the cloud, and make sure that you know that the only way they're going to go in and look at it is if they need to do so to correct some technical side of it, but that they're not going to use your data, they're not going to disclose your data to anybody else. You really need to read those carefully.
Okay, good. That's a good warning. Anything to add there, Linda?
Nope.
Okay. And Kathleen's, just for clarification, she thought you mentioned that you recommended that we keep notes about a verbal warning in the personnel file. She was under the impression that it needed to be separate. Can you just clarify for us?
No, it doesn't need to be separate. I just was suggesting that many times there never gets a note to the personnel file that there's been a verbal warning, and there should be. There should always be. Anytime there's been a verbal warning, even though the employee didn't receive it in writing, the personnel file should be noted. We warned Susie Q in my example that she didn't have her safety glasses on. My suggestion was, if you have supervisors who say, I can't be bothered with advising HR or accounting or whoever is keeping the personnel files, every time I do a verbal warning, because I do them a lot, find some other way to keep track of it so that when we do need it, when you come to me and say, I want to terminate this employee, and I say, well, this personnel file looks like it's the greatest employee ever, but I've given all these verbal warnings. Let me have something to look at that says when and where, when and how, or what the warning was. And my example was of the blotter. I can tell you that some outside salespeople, outside sales managers, they use note-keeping in their iPhones. And if we need to get it, we get it, we print it, we get it into the personnel file before it gets turned over to the plaintiff's attorney.
Yeah, and Julie, let me just jump on that. So what I usually advise is, because Marla likes blotters, I like everything electronic. So normally what I would say is, look, just shoot a quick email to the HR person. Shoot it to yourself. I mean, whatever it is, just so you have a record of it. But once it gets to a written warning stage, if you're going in that manner, I always tell people to reference any prior verbal warnings that you've given. So if you can say, look, we talked about this, on 3 prior occasions. It's great to be able to say on, January 10th this happened, on March 12th this happened, or as you'll recall, on March 12th we had this discussion. And it's great if you can reference something. So wherever you put it on a calendar, make a calendar entry, you have an email that you sent to HR, they print it out and put it in the file for you, whatever it is, just make some sort of notation somewhere, whether it's electronic or in paper, so you can reference it later.
Great. Thank you very much. Marina has a question regarding paychecks. Is the employer required to show the punches or clocking in and out in their paychecks or not?
No, they're not. Just the hours worked and at the rate of pay.
Okay.
And those other 8 items. Yeah.
Okay, good. And Linda, you had talked about accessing personnel files. Do we, as HR people, need to document who accessed the files and for what purpose?
No, there's no requirement to do that I know of, Marla. No. There's no requirement to keep track of who accessed them. I mean, and here's the thing. I never let a personnel file leave the HR area, so I was telling Marla, yeah, I made that mistake once early in my career. She was pointing at me. Once early in my career, a CFO came and asked for a manager's file, and I gave it to him, and then I went back later in the day and said, can I have that file back? And he had sent it off to the attorneys and just put the original in an envelope and sent it off. And so, of course, my head about exploded. And so from that day forward, I've always had a rule that the originals never leave the property, they never leave the HR. Again, if somebody wants to see them, that's fine. Come to the office, sit down. I'll pull whatever it is that they need out of the file to have them take a look at it. But I've always kept really, really, really tight controls on the actual HR files so they don't get lost or modified or damaged or anything like that.
Okay. Yeah, and to my earlier point about sending the file to the attorney, I have a client who just sent me an original personnel file, which I but must not have communicated very clearly. I don't want the original either. I want the copy because I don't want the original really to leave the site unless there's litigation. So, and usually that helps me because if I get a copy, then I know that that's a copy I can send off to the attorney who's asked for the documents or the employee or former employee who's asked for the documents. Because we didn't talk about this, but they do not have to be given the documents on site. And of course, if it's a former employee, you really don't want them back on site.
Oh, good point. Yeah. Okay.
So that was a long answer to a question that wasn't asked, but the answer to the original question was no, you don't have to keep track of who checked out a file or who viewed a file.
Okay, great. We are wrapping up right now, and I just want to real quickly see if I can get back in here. And I know for, and I'm not slighting you or anything, Linda, but I know for Marla, a lot of people have texted in and they want her email address to send her specifically a note. And again, we're going to follow up with some of the information we talked about earlier, but I just put Marla's slide up real quickly. Her email address is marla@mrjclaw.com. So for those of you asking right now, go ahead. You can send her an email. But again, we will be following up with a packet of that information. And then I also want to, and I don't know if Linda or if Marla want to talk about what we have coming up here, but we have a pretty lively webinar schedule coming up. Linda, did you want to talk about that, or did you, Marla, cover what we're going to be?
Yeah, the dates are right there, and it's always going to be 11 o'clock on those particular days. The next one's going to be May 22nd. Some of you may have heard Lawrence last year. He's a fabulous insurance broker. We do a lot of business with him, both Marla and I do, with Oak Ridge Advisors. He's the president of Oak Ridge Advisors. And so he's going to be talking about, the changes going on with Obamacare, with Affordable Care Act, and what employers need to know. And last time what we did is we had him break that down between under 50 employees and over 50 employees. And so it doesn't matter what size your company it is, he's going to provide you with some really valuable information. June is going to be a very hot topic. We've done this webinar before, and just because of the change July 1st going up on the minimum wage, it does change the salary levels on the exemptions in California. So we thought it was a time to go back over and remind people about who can be salaried exempt and exempt from overtime and who should not be. So we'll be talking about that in June.
Okay, great. Thank you so much for sharing that. And again, on behalf of both Linda with Ethos Human Capital Solutions and Marla Merhab Robinson with Merhab Robinson, Jackson, and Clarkson, I'd like to thank you all so much for joining us and accommodating our schedule change again. Remember now what we'll do is follow up with an email to all of you, and it will include not only the presentation that we used today, a link to the webinar, and a list of the wage statements, and then also a list of what the posting should be in the company. So you'll basically have 4 different links that you'll, and I know for those that are more anxious, feel free to email Marla directly. Again, we also just here in the presentation as well, and I'll also include a link in the email, a link to register for the Affordable Care Act webinar on May 22nd at 11 a.m. So again, we appreciate so much the fact that you chose to spend your time with us on this webinar. We look forward to providing you with all this useful information. And again, if you have any suggestions for future webinars, certainly contact us. And on that note, please have a great day. Thank you so much.